Good afternoon, everyone. I'd like to call this meeting of the Mayor Council to order, and we'll go in the process of setting the agenda. The published agenda, we have approval of the minutes and then consideration of attached motions and then a request for approval on a Sheriff's Office job description. I'd like to reverse the order on C and D and have the motions as the last item. So that way, if we have any individuals that need to leave from the Sheriff's Office that are doing the administrative function on the job description, we can go and excuse them expeditiously. Anybody have any opposition to that? Hearing none, we'll set the agenda as I stated, and I'll entertain a motion to approve the minutes of the last meeting.
Motion to approve.
Second.
Mr. Vaughn and Mr. Marshall, any discussion on the minutes? Hearing none, call for the question. All in favor?
Aye.
Any opposed? Thank you. Okay. Sheriff, who's the representative that's going to speak on the job descriptions, sir? Thank you. Chief Purvis, if you could come forward, please.
Yes, sir.
Good afternoon.
Good afternoon.
Please proceed, sir.
This is a job description that was already an existing position, which we realized after Buddy Burkhart retired that we did not have a job description on file for Mr. Burkhart's position. And when we went to fill it, we realized that we didn't have a job description, so we're just presenting already existing positions job description.
And just for clarification, this is the maintenance technician position?
Yes, sir.
Thank you. Is there any questions for the chief? I'll entertain a motion.
Move for approval.
Second.
Second by Valiant. Any discussion? All in favor signify by saying aye.
Aye.
Any opposed? So moved. Thank you. Thank you, Chief.
Thank you.
Okay, so now we have the attached motions that are with the agenda. I'm going to take these in basically reversed order to deal with the ones that will probably not have much discussion, if any. The motion to propose amendment to the rules and regulations 6.1.3, and this is where corrections and patrol officers must have a valid driver's license. Have all the board members had the opportunity to review the motion? Are there any comments on the motion before we vote? Seeing none, discussion. Do I have? Ms. Taylor, could you tell me if I have a second on the motion on this motion already?
I didn't hear one.
Okay, so I have the motion, and I'll need a second on this.
Second.
Second by Valiant. Hearing no discussion, call for the question. All in favor signify by saying aye.
Aye.
Any opposed? Thank you. Okay, that one's done. You want me to sign these or the stack that you gave me?
Either's fine.
Okay, we're going to deal with the second motion, or the policy of requiring a leave of absence to run for the position of sheriff. We had a fairly extended conversation about this last meeting. Does any of the board wish to make an additional statement?
Was this one under Regulation 2.3 or 3.2?
I'm sorry. 2.3 and then the county ordinance section 42-53C. Okay.
I just want to make sure. Originally, we were discussing at the last meeting the qualifications. I guess we were saying that they should. We were speaking about this, I know, directly in the context with running for sheriff. And I was hoping to make sure that, I guess, and it looks like it is, but that the amended language, I was wanting to make sure we broadened it to make sure that it was, I guess, they could run for any elected office, not just,
Right.
okay.
I agree with you, yes. Does anybody in the audience wish to speak regarding this motion? Anyone from the sheriff's office wish to speak? Mr. Vaughn?
Yes, so we're speaking specifically about the Rules Regulations 3.2 in Knox County Ordinance, Section 42-53C, correct?
Correct.
Talking about specifics on running for elections and outside of the sheriff's office.
Well, both the sheriff, position of sheriff and any other elected position.
Right, okay. So just having a chance to read through this and look at it, just kind of thinking about my service when I was the executive director for the Police Advisory and Review Committee. One thing we did as far as on the city side is make sure that we have a sense of clarity, transparency, but also nothing that's going to muddy conversations, particularly dealing with officers. I would have hoped somebody from the audience could have spoke as far as from the sheriff's department or even our county commissioner, if we have anybody here, to see what benefits that is. Because I'm thinking right now, this with the climate that we're in is very partisan. Thinking about bringing that into this body and having where it's more, it could be politically driven if somebody had some hidden agenda on this board. So for us to consider that and think about what that would be an impact. And also with this being fairly new, I asked Paula Taylor as far as when was this indoctrinated or when was this created. I think it's been a couple of years now as far as this new ruling.
A little less, but I don't have the exact date.
Yeah, and knowing that we're coming up on a political season, I mean, we have a lot that's going on here in the city and county and also nationally, to allow either it to be postponed or allow this motion to be removed, mainly because keeping this body where it can be not just bipartisan, but open and not influenced by political campaigns or partisanship. I think that would be something we need to consider or discuss as a board, and I welcome anybody else that wants to add to it.
I agree. I believe, if I'm not mistaken, that may be the third motion we're looking at, which is this conversation is about being a candidate, and this motion over here is about whether or not members of this board can participate in any campaign. So that's a separate conversation, and unless I'm misunderstanding you, because currently the rule is if you're an employee of the sheriff's office and you wish to run, you must take a leave of absence. And the conversation was that you may be hamstringing the candidate pool for elected positions by causing folks to suffer a financial hardship if they decide to take a leave of absence because they're not receiving their salary while they're campaigning. And that was the scope of this conversation. I mean, your points are well taken. I just wanted to make sure that we're on the same page.
No, we are. I want to add that to the conversation
Okay.
before we move to that.
Sure.
See if you're be enlightened to have a further conversation about that particularly. But the
Right.
leave of absence, I'm in agreement with that.
We can, I'm, excuse me. The draft of the motion wouldn't be moved on until we finish out our conversation, and we can defer or vacate if we wish to do that as a body. The next one, are you of that opinion with this conversation
Yes.
about them running? Okay. Is there any other comments?
Clarence,
Yes.
were you aware of the memorandum from the law director's office?
Yes.
In reference to the Hatch Act? Okay.
Yeah.
Any other comments from the body? Okay, I have a proposed motion. Do I have a second on this motion?
Second.
Do I have any further discussion on this motion? Mr. Vaughn, I see your light lit. Do you have any more conversation? Okay, thank you, sir. Thank you. Hearing no further conversation, I'll call for the question. I believe, based on the conversation, I'll go ahead and poll the membership of the board. So the motion is to allow members of the sheriff's office to run for elected office without having to take a leave of absence. And that includes the position of sheriff or any other elected position at any level of government. So I have a motion and a second, and if you approve, Mr. Vaughn, do you approve?
Vote for approval.
You vote for approval. Mr. Gates?
Vote for approval.
Approve.
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 I approve. It's unanimous. Thank you. Okay, the next proposed amendment to Rules and Regulations 3.2F and Knox County Ordinance Section 42-53C. And this is for the, currently it precludes any member of the Merit Council to participate, or let me quote it, "No person holding a position on the board shall take an active part in any political campaign for the election of Knox County Sheriff while a member of the board." The intent of this regulation is to ensure that this body is apolitical. The way they got to these regulations is based on some past performance of members of this body. So there was a desire by the commission to enforce an apolitical posture within the members of this body. So unless there was conversation about the participation in any elected, any election or any campaign, and the text of this shows that it's just the Knox County Sheriff's Department. That's what we're trying to accomplish, is to stay, the Sheriff's Office, is to make sure we stay apolitical on that, but it would allow members of the board to campaign for mayoral, congressional, U.S. Senate, state Senate, presidential, and if I read it correctly, even the county commission positions. So I'd first of all entertain if someone wants to submit a motion and a second on this. Mr. Vaughn.
Well, before we move to that, that's what I was bringing. So
Right.
I actually referenced it before I made my comment. So
Okay.
I said rules and regulations 3.2F. So that's what I was
Okay.
discussing. So just know, going back to what I said earlier,
Right.
having an opportunity to work for a mayor's office is knowing how things are already aligned. So you may not run, one of us may not run for sheriff, so to speak. We run for county commission or any other office that still aligns with our law enforcement and with our public services. So that's why I was making a comment about, just getting some conversation from the board to get our thoughts on, one, what's the benefit, for the board and also for the sheriff's office. I think the most important reason for this board is to make sure we're serving in a transparent manner and not being influenced in any way to make decisions that help our officers in our community. And just knowing, again, if it's a partisanship matter, somebody could, not say us in a sense, but somebody, maybe here in the near future or the next future, come in with a hidden agenda to have some perceived notions if they're running for office, then they may be running on a campaign that's involving police safety, community safety, and everything else, making sure that that does not muddy conversations that things are going to be done from this body that will help support our sheriff's office. I would love to open up a conversation and also welcome anybody from the sheriff's office or from the community that's here with us to speak on that, because I just have concerns reading through that, just seeing where the gray area could be, just having experienced that in previous positions and working in our form of government here. That could cause some concern. So what I was going to recommend, asking, as I shared earlier, speaking with Paula, since this is less than 2 years that's been in existence, for the board to consider either allowing us to go through a full political season that we have right now and revisit this, or modify the motion back to where it was, to keep where we're serving in the servitude of not being able to run for mayor, not to be able to run for clerk, or whatever those other positions are, to have that political influence removed from the body, if that makes sense. But I would love to open it up for conversation and also welcome anyone else who has some also thoughts on that.
Thank you. Is there any other, thank you, Mr. Vaughn. Any other question or comments? Mr. Marshall?
As I'm understanding what we discussed last time, what the law director has put into this form is that if a member of this board decides to become politically active as far as running for office, they must resign at that point. So I think that would I can understand what Clarence, what you're saying in reference, and this board has experienced that, and a lot of money was spent by the taxpayers in defense of that. So that's just all I wanted to say. I wanted to say that it is clear that if we decide to become a candidate for any office, we must step down from this position the minute we make that declaration.
Any other?
Respond?
Certainly.
Thank you, Mr. Chairman. No, thank you for that. I'm very fully aware, but I'm thinking about political influence. So even if you're not running for an office, this does give us the opportunity to have that influence. Am I correct? When it comes to campaigning and everything else in that regard. So that's the language I'm mainly speaking of. Of course, if you run for office, if I was working in the mayor's office I ran, I would have to resign from my position. Same thing you would as a community member serving in a volunteer capacity. You would have to recuse or, of course, resign from that role. It's not talking about elected office, but also a political influence that can really impact our decisions as a board.
Right.
So the very nature of the existence of the board is political.
Any other comments from board members? You just identify by light so I can call you at appropriate time. Mr. Valiant. Thank you.
I think one of the things that we had kind of bounced back and forth at the last discussion was the, I guess, kind of the constitutionality of this in the first place. This is kind of a restriction on First Amendment rights, and especially because this is a volunteer board. I think the issue that I have with that is just simply, in a volunteer capacity, I have trouble, especially after doing the research on the constitutionality of it, how any government entity can restrict the political activities of a volunteer board, especially when political activities would be involved with. We very clearly interact with the sheriff's office on a regular basis. The whole purpose of this board and the purview of this board is intermingled with the duties of the sheriff. And so from that standpoint, I think there's absolutely, a need for an apolitical nature with regards to the race for sheriff. But then, broadly speaking, the way that the language of this is previously or has been drafted, it's just oppressively large and kind of overbearing. And it would kind of have the, it would say that, if you were to be involved with the presidential race, on a national level, that it would be in conflict with this board in a volunteer position. And I think we talked with the law director's office, and there was a informational meeting, I guess, with commission, where we talked with the law director's office, and they had said that really there shouldn't be, constitutionally, there really shouldn't be any sort of a restriction on that, I guess, kind of First Amendment right to be able to work with that. Now, I think we did kind of come to the consensus that any involvement with the race for sheriff, that absolutely makes sense. And I couldn't agree more with you there because of the overlap. But then, for example, the race for the, President of the United States or, the state senators, wouldn't seem like a volunteer board would be involved with that in any way, or there would be any sort of a political influence or overlap from that standpoint. Was kind of I think the conversation that we had up to this point.
Thank you, Mr. Valiant. Mr. Getz.
I agree to some extent. Well, I agree fully that transparency is necessary insofar as acting as a functioning board. I disagree to some sense of whether or not the speculative nature of impropriety in and of itself is enough to say, hey, we shouldn't be involved in any political activity, or, because the thing is that that's such a broad description insofar as maybe just donating a couple bucks to whomever, or what I'm trying to say is that it being so broad kind of, in some sense, limits my, well, how it was before, it was being so broad that it kind of limits the nature of the thing, right? I think that the idea of being apolitical to some degree is a good thing. The board should do its best to strive for that, but that again, that's going to be more of like a moral high ground kind of thing. It is, we should do our best to strive to be apolitical and make sure that these things don't interfere, because we ought to be, to the best of our ability, free from impropriety, right? The issue is that because of the nature of the thing is so speculative and so broad, it's hard for me to sit here and say that we shouldn't move forward with this with an understanding that these things are lurking out there. Because I think we can all agree that political influence likely influences more or all the decisions made to some standard, whether or not that's, a few degrees of separation removed or very close there too. So in my opinion, I appreciate the idea of this needs to be as transparent as humanly possible. I just don't think without something else that it ought to be so broad to limit all political discussion. And so that's more or less what I have.
Can I respond?
Yes, sir.
This is another comment. So, understanding this is a political body, of course, that's the purpose of what we're doing. But going back to what you shared, and I think it's a really good comment, is looking over what was listed and listing as far as what can and can't be done. And I know we kind of changed our language and really drafted and massaged it towards focusing on the county sheriff's office as far as that being focused. So as far as political campaigns, endorsement of any candidate, any campaign, of course. I'm also looking at everything that's listed in here that's related to the sheriff's department. I'm definitely in fully agreement. I know still here, you still can have a political affiliation with the club. Everything is still in here as far as giving that civil rights of somebody to do that if they choose to. So would it be of the board's thoughts to make it on a local standpoint from a city, county? I understand from a presidential race, that would be, in a sense, what you shared, John, is very valuable as far as having that person having the right to do that. But looking at a local city or county influence and knowing how the influence can be perceived from the community, but also those who are on the board. Just your thoughts on that. I'm primarily focusing on local ran races. So that can be anything under the umbrella of the Knox County, we'll say Knox County government, I must say the Knox County government. And just want to get your thoughts. It's really more so I just want to have conversation to kind of get more clarity before I do vote for approval or non-approval or make a recommendation to you, Chairman.
Thank you. Any other member have a comment? I'll weigh in. Yes, sir. Mr. Jay, you'd like to speak? Thank you, sir. Good afternoon.
Good afternoon. Thank you, Mr. Chairman, and thank you, members of the board. My name is Larson Jay. I'm Knox County Commissioner at Large and proud to represent all of Knox County. I was sort of the key architect of leading many of the reforms for the Barrett System Board of Directors. That effort started 3 or 4 years ago, and many of those reforms were passed, I believe, a little last year, a little over a year and a half ago. And this board has done an excellent job of coming together and finding ways to make this a better system. And so on this particular topic, I think it is prudent to recognize your opening statements of the reason that this was put in place and why the commission adopted it was because of past deeds or an entity that had become so political that the officers that I spoke to often said, I would never go to the merit system because I'm not in that camp. I'm not in that fiefdom. I'm not in the right bucket. And this is an organization, this is a board and a body that is here for the support of our officers. And so I would ask you this question: to what benefit to the officers is adding more politics to this board? If this board is here to support our officers and protect them based upon a set of clear rules and regulations and expectations, and is also here to arbitrate issues between a sheriff duly elected, but also a set of state rules and regulations, what benefit does it have to serve on a voluntary board when your sole purpose is to interpret the rules and regulations, make decisions based upon decisions that a sheriff makes or that a officer feels as if it is grieved. To what benefit? There's more politics involved in that. And that was the purpose, was to take politics out of the equation and say, the purpose of this body is to do X, Y, and Z. And you all have demonstrated that you've done that over the last year and a half. And to interject more politics into it, I don't think makes a better system for our officers. It's interesting, the very first thing that you passed, certainly that will go to commission for consideration and maybe codification, was that any officer could essentially run for any position and did not need to take a leave of absence. So let me play a scenario out. Let's say Officer Digby, I'm going to just name one, I'm just going to make up a name. Officer Digby was a captain in the sheriff's department, and he decided to run for county commission. Okay, you all, based upon your vote, you say that that's appropriate and he should be able to do that. Now let's say one of you board members have decided to get involved with a political race against his opponent and donate and go out and put campaign signs out and be politically active. How does that put you in a position if you were to win or to lose that commission seat? I think a terrible position. But yet, if you allow any member of this board to participate in any political race and you allow any member of the actual rank and file to run for office, you're going to create a terrible scenario in which there's no way that that can't affect your judgment. If one of you all are campaigning for his opponent or even for him, and he has a grievance against the sheriff and maybe somebody else is running for sheriff, you can see how this could get really muddy really, really fast. I think on a local and a state level, whether it's clerk, whether it's commission, whether it's sheriff, whether it's state senator, House of Representatives, politics should never be part of this body. Now, you may want to open it to a federal race to say, hey, I want to go campaign for the next president of the United States. That, I think, is a completely different scenario. But in that local sense, adding politics to this will only create situations in which somebody questions whether this board is objectively looking at the rules and regulations, looking at the facts, looking at the grievances, and looking at the policies in a way that they can know that they have the protection as an officer. So I would discourage you from adding this. If nothing else, Mr. Vaughn has a point. We haven't even been through a political cycle yet to even test the waters. At best, table this, but please consider not adopting this and sending it forward, because this body, it works for our officers, and they should never doubt whether they can come here because of political alliances. Thank you for your time, and I appreciate the opportunity to speak.
Thank you, Mr. J. Anybody else from the audience wish to address the body? Okay, I'll go ahead and make some comments. Mr. Vaughn, I agree with you. Maybe a little premature. There is no exigency on this. We'll have several cycles, hopefully, in our lifetimes. To be very blunt, we knew this when we took the position. It wasn't added. We were asked specifically by members of the commission when we were interviewed if we were going to run for office. I can assure you publicly on a recorded meeting that I will not run for office. Yeah, I like myself too much. The apolitical position of this body, I believe, is, after all the machinations and evolutions of the regs, I think that is the linchpin of the standing of this body, is we're not influenced. I think we are conducting ourselves where we're calling it based on facts. We're not being influenced by any type of pre-meeting conversations or the personalities involved. I'm very proud of all of you and the way we've conducted ourselves. And I think, to Mr. J's comments, if we muddied that, we may sully the reputation of the board, simply because if there's a perception of influence, either way, either we exert it or we receive it, we're not serving the employees in the most objective manner. I want those men and women that have some type of a behavior issue at the department and they wish to come and be heard, that they know that we're going to give them a fair assessment, fair evaluation of the facts that are presented. Give them the opportunity. I mean, you as a body even heard from a person who, or an appeal or an attempt to appeal on a person that didn't even work for the sheriff's office. I mean, that's how much of a fair-minded body this is. So, again, I'm as the chair, I'm very protective of the apolitical nature of this and would hate to see the influence on that. Mr. Valiant, you had a comment, sir?
Yeah, I struggle with the notion that I hear the comments. I struggle with the notion that you couldn't maintain an apolitical nature and be on this body. You know, it seems to me like the picture that was just painted is that you can either participate in a local election of some kind, or you can be on this body, and it's either A or B. There's no C. There's nothing. There's no in between, and that the only opportunity is you can either be a member of the Merit Council, or you can participate in a political campaign. That there's no opportunity for any sort of right in between. And I know we just painted a picture of, hey, there exists this opportunity where you could have somebody, an employee of the sheriff's office wanting to run for office, and that they could at one point have a grievance, and if you were put on the other side of them in that election, that it could potentially cause some issues. The piece that I struggle with still is, we have judges, we have members all over the county, I guess government employees and individuals who have run for office who can participate in political campaigns currently. If I'm not mistaken, as a county commissioner, I think you can participate in political campaigns. I think you can run for political campaigns, you can run for office, you can participate in campaigns, you can support candidates, and while it may not be politically wise to do that, if you were to position yourself with somebody that potentially could, whose views could reflect on you, there's nothing that prohibits it. And I think still there are some issues with preventing a volunteer body. Constitutionally, every individual has a right to free speech as granted to them by the U.S. Constitution. And, embodied in that right to free speech would be the right to be involved in, any sort of political activity. And I do think it's correct when every single person was sworn in, we agreed to follow the rules that this body put forth. I think the problem is I think some of these issues, we've had the discussion of these issues on several occasions. And I guess the problem that I've got is I still think that there's some unconstitutionality behind it. And I think even when we brought it up in front of the law director, he agreed. I think that we, I think that being apolitical doesn't necessarily mean, having the inability to work with other individuals. And I think that if there were a conflict of interest, just like a judge would potentially have in some manner or capacity, a member of this body would have the opportunity to recuse themselves. And I believe, if we're talking about the specific items that led to the original change to the rules and regulation, my understanding is that it involved an individual who was a member of this body who came to a meeting decked out in political gear to, in front of the officers and in front of the county. And I think that was, it was in a public context, it was in a public meeting, and they had, so-and-so for sheriff hat and so-and-so for sheriff badges and stickers, but, it really had nothing to do with, the race for our local trustee or any other position. I think and that context, it seems totally inappropriate that that happened. But, you know, to broaden it and to create its own, you know, a set of rules that applies only to this body and that doesn't apply to any other body surrounding county commission or just surround any other body to include, you know, county commission or any other governmental agency, especially a volunteer body. That kind of troubles me a little bit. I apologize. I probably could have stated all of that in a more succinct manner.
We're paying you by the word, Mr. Valiant, so it's fine. You're good. Mr. Vaughn, did you have a response?
Not a response.
Oh, okay.
When I'm thankful for the conversation, that was the main purpose of my initial remarks. And just kind of to piggyback on what John shared, I'm in agreement, but I'm thinking too, thinking about my Rotary, when I was Rotary service above self. So it's more individual when you talk about what the individuals can and can't do. And I like what Commissioner Jay shared, what is the benefit to officers? You know, when we have, at this point, if it's not a sheriff's race, someone could come in with a political hat button, if it's federal, as you shared, or a mayoral candidate, if this is put into existence, am I correct? Outside of the sheriff's office. You can still campaign. Right.
Yes.
Okay. So this
Would it be recommended?
Of course
No,
not.
there'd be a conversation with the member because, I didn't mean to interrupt you.
No, go
I'm
ahead.
sorry. Tacit campaigning during a meeting is not appropriate. I have an opinion about the prior member's behavior and whether or not that should have been addressed, but I don't see anybody on this body doing that, knowing you the way I do, very professional, and you've got your mission focus as opposed to that mission of supporting your candidate. But go ahead and continue. I didn't mean to.
No,
cut you off.
we're in agreement, and I would never assume or suggest that would be something
Right.
that this body would take place in.
Sure.
But we're the current body. You know,
Yes.
we don't know who may come in 10 years from now, 20 years
Right.
from now, putting this in existence. And there may be another conversation that comes up that be brought before the body to have this discussion. So, my thought, and I was going to ask if the chair was open to proposing an amendment to the motion to include where it's focused on local, primarily local elections, particularly to Knox County government would be my thought. Outside of, because our jurisdiction is really focused on serving in the volunteer capacity to the sheriff's office, which is under and tied to Knox County government, to really focus on language as an amendment, or as I said earlier, we can, and I think Commissioner Jay shared it, table this to go through a full political season because we are in the midst of that right now and revisit this as a conversation. That would be my recommendation if you entertain an amendment to the motion, either to the language that we have listed, so that way we won't have any conflictions that could potentially come. We know our character, and I would never question anyone's character on this board, but I'm thinking about who is sitting, I'm keeping the seat warm for somebody behind me. And when they would come into this space, what do we leave the door open towards potential things happening? And I agree 100% with Mr. Valiant's comments in regards to protecting our amendments, our rights and our rights as U.S. citizens, but also we have a service above self on this board. So I want to make sure there's no interpretation or anything coming from us that will reflect to anyone, officers or community, that we really have ways where we're still apolitical, but also bringing that influence between the back door. So I would offer that to you, Mr. Chairman, if you
Thank
would
you.
want to entertain an amendment to the motion to include the language that's listed as involving any election of Knox County Sheriff, to change that into Knox County government, to make it more of a local government focus. And I will also state, it's something we consider, but I'm primarily focused on who we have the immediate touch point to, which is Knox County government.
Thank you.
Or again, table.
Before I entertain your request, I'll speak to your coworker, sir, Mr. Gates.
No problem. One more comment. I believe all else we should stay in a sense, or with the sense of impropriety should remain. I believe that our purpose is to the men and women in blue, and I believe that should be our focus. I think at the same time, we can strike a balance between overly broad and restrictive policies with that same sense of keeping to our primary purpose of serving them. And that's all.
Thank you. Mr. Marshall, did you have something?
it would seem to me at this point that there are some conflicted ideas about going forward with this as it stands. I would suggest something for us to think about is going along with what Commissioner Jay said. Maybe we table this thing and do another deep dive on how we can word this so that we don't conflict with people's rights to be involved in the political system, and at the same time insulate us as best we can. Nothing's going to be perfect. Insulate ourselves from making sure we don't create a conflict within the Sheriff's Department. And, you know, going forward, we have an election here in, 3.5 years. There's no incumbent running, so there's naturally going to be probably some conflicts inside the Sheriff's Department as they divide. We don't want to add to that.
Any other comments? So, to Mr. Marshall and Mr. Vaughn's points, it's conflicted at this point, and I don't see any exigency. I see an opportunity for some more examination and peeling back the onion, so to speak. And I defer to the law director representative. Mr. Morton, would it be appropriate to appoint members of the body to do some evaluation and meet with you to propose the text of an amendment and then they bring it back, or is that appropriate?
It's my understanding that the rules allow that, yes, sir.
Okay. So I'm thinking 3 members, and I'm thinking if Mr. Vaughn, Mr. Valiant, and Mr. Marshall would be willing to meet on that particular item and work with Mr. Morton and really get into the whatever vernacular you want to use, meat and potatoes of it, or whatever you want to call it, and just look at it, and maybe we get everything vetted out, and we'll come up with a better solution. But all your points are well taken, and I think it's just best to do that. So then at the end of the meeting, we'll set whatever you think is 30, 60, 90 days is appropriate, and we'll move forward. Do you agree with that, John? Okay, thank you. Okay, we'll try to take as long on the next one.
Should we propose a motion to table this? Or to
Well,
push this?
I believe I can just state that we took no action on the proposed motion, and we just are vacating it without it. Okay. Ms. Taylor, you recorded that? Okay, thank you. Okay, so the fourth proposed amendment is Rule 9.5 of the Rules and Regulations and Knox County Ordinance Section 42-62B. And this is the conversation where there was a grievable action by an employee is if there's a loss of pay or a suspension longer than 3 days. And the conversation was that a 1 or 2 day suspension is a loss of pay. And based on our current rules and regulations, that is not grievable. So they would not have recourse to visit the merit board. And it seemed to be a contradiction. There has been some conversation that this standard of 3 days conforms with state law. And I asked the law director representative, Mr. Morton, to research that, and he was unable to find exactly what has been comported that is what section or either a legal decision or an actual codified section in the state constitution or otherwise that shows that any suspension less than 3 days is not appealable or grievable. And Sheriff, would you be willing to step forward? And okay, thank you.
Good afternoon.
Good
My
afternoon.
name is Mike Rubel. I'm Chief Counsel with the Knox County Sheriff's Office.
Thank you very much for coming, sir.
I have been in that position since September the 1st of 1990. Before that time, I was with the Law Director's Office, and I represented Joe Fowler and his Merit System Council. I'm intimately familiar with the Merit System Council
Thank you.
rules. The statute that you're looking for is the private act that established the Knox County's Merit System Council. It's a private act, private chapter 326, was passed in 1977, section 17. It talks about the sheriff shall give an immediate report in writing of all appointments, reinstatements, vacancies, absences, or other matters affecting the status of any member of the classified service or performance of the duties of the members of the service. The sheriff may suspend any employee for not more than 3 days for cause, and there shall be no right of appeal for any suspension thereof. That's in the statute itself. This statute is particular to Knox County. There is a state statute that was passed in 1973 that date was 10 days. So in the state statute, we have the sheriff's office has the right to suspend without right of appeal for up to 10 days. In Knox County, they've limited it to 3 days. From the position of the sheriff's office, and I've talked to Sheriff Spangler about this, this represents the legislative balancing between the interest of the sheriff being able to run the sheriff's office with regard to not having to appeal to an administrative body that is appointed by somebody else to do routine matters of discipline inside the sheriff's office. So they have decided for 10 days, they've decided for 3. Our objection to this rule change is that this puts you intimately involved in routine disciplinary matters in the sheriff's office. The sheriff is going to have to ask you for permission to discipline his officers, and I'm here to tell you that's not going to fly. We got involved last time, and I appreciate, this is the first meeting I've attended. The last Merit System Council got itself intimately involved in stuff that it shouldn't have been involved in. And there was a huge piece of litigation right there towards the end where they were involved in the assignment of a car. It cost the county a couple of $100,000 to get through that litigation, and the end result is the election was had. All the cases immediately went away within 2 weeks. They were all politically motivated. You want to stay out of that mess, and all we're asking you to do is please let the sheriff's office run the sheriff. Please let the sheriff run the sheriff's office. We don't threaten litigation lightly, but this will be a fight. The sheriff's office, the sheriff has indicated quite clearly he is not afraid to engage in litigation. If this is where y'all go, because it puts you in charge of routine discipline. Anything more than 4 days, anytime we suspend somebody for more than 3 days within 6 months, y'all are involved. Any demotion, any termination, y'all are involved. 3 days or less is routine. Okay, and just want to let you know that's the position of the sheriff's office. I don't know if Chief Lyon wants to speak to that or not, but that's where you're looking for. It's in the 1977
Thank you.
Private Act.
Excuse me a second, Chief. Could you just stand by? I just want to make sure. Mr. Morton, do you have that? Do you have the citation? Do you have the legislative number?
Yeah, I know what he's referring to. I wasn't aware it was in effect currently today, but when I can give my opinion,
Okay, I just thank you for your time. I just want to make sure that the law director's office has that. So when we,
I will address, and what he's saying is, of course, all the private acts have been subsumed into the charter. What I'm telling you, and I think Myers and I can agree on that, what I'm telling you is that is the legislative position with regard to this balancing act between the sheriff and the administrative body. 10 days under the General State Act, 3 days under our act, and now y'all want to move it to 0, and the sheriff is not good with that.
okay, thank you.
I'm Chief Deputy Bernie Lyon. I'm involved in most of the suspensions. I always lean toward the lenient side when I suspend somebody. Having been with the sheriff's office coming up on 45 years, I would compare this to disciplining your child. If you discipline your child and he knows he's going to get disciplined for what he does is wrong, he's not going to commit that act again. And then he's going to run to your grandparents, his grandparents, and tell them what you've done, and they're trying to correct you. It's just not going to work. Your child has to understand that if he makes a mistake, he needs to pay for it.
Thank you, sir.
Thank you, sir.
If I may.
Yes, sir.
I apologize for not making this point earlier. I checked with my HR staff in our recent memory, just make sure we understand what this issue is about. We have a total of 2 suspensions in recent memory that were for 3 days or less. So the fight we're about to engage in is really not worth the candle. The game is not worth the candle. The candle's not worth the game, whatever that old phrase is. Thank you very much. Sorry to.
Thank you. No, you're fine. Thank you. So, Mr. Morton, based on this new information, do you have any advice for us?
The sheriff is a constitutional officer recognized by the Tennessee Constitution, Article 7, Sections 1 and 2. In the legislature, the county commission, this board has no power to deprive an officer of a substantial part of his jurisdiction, rights, and authority which existed at the time the Constitution was adopted. And I'm reading from a case from 1897. It's clear that the sheriff's constitutional officer is entitled to autonomy. However, the law also says there is a well, and I'm quoting the case, 1897 State versus Cummings, there is and this doesn't conflict with a well-recognized right of the legislature to regulate the fees of the sheriff and management of his office. I can find no constitutional prohibition to keep this legislature from helping regulate the management of his office, of the sheriff's office, constitutionally. The state civil service laws adopted by the state legislature does say 10 days, but Knox County, frankly, Knox County, the private act Chief Rubel talked about, was pre-existed. Knox County had a merit board before the state law was even passed, but the local county commission at the time decided not to take that 10 days and to make it grievable after 3 days. But I have researched this, and I, at this point, can find no constitutional basis that does not allow this board to decide on this issue. There's no prohibition constitutionally for this board to make this decision.
Okay, but the question, okay, so based on what the chief just told us, below 3 days is within it's a legislated purview under the chief's, or excuse me, under the sheriff's position. And are you telling me that that law is not the law of Knox County? Because it sounds like we're in direct conflict with the legislated act. And if it's legislated, that means the people's representatives voted on it and passed it. And I'm trying to understand that are we not following that law that was passed, or is it no longer valid? You just stated that it predates the 10-day suspension restriction, so it's actually gives the employees more opportunity to grieve because it's 3 days as opposed to 10, if I'm following it correctly.
The 10 days doesn't apply to Knox County.
That's what I'm saying.
Knox County is only 3 days.
Right.
And the question is,
So-
and what this board is considering doing is taking it down to 1 day.
Right.
And my legal advice is that there's nothing constitutionally that forbids that. That this board, nothing forbids this board from making that determination that it's 1 day. Constitutionally. And the state merit system laws don't apply to Knox County because Knox County went their own
Right.
path.
But okay, Chief, go ahead. Sorry.
No, I just want to address, Myers and I are not in disagreement with that. I am not telling you that it is unconstitutional. I'm
Right.
telling you it is horribly bad policy, and it
Right.
is in violation of what the state has already determined to be the balance point. So don't get confused by constitutionality, unconstitutionality. I'm not making that point. I'm not saying that,
Right.
that there is no authority for this rule change. My problem is that this rule has been in existence in Knox County, as he correctly points out. We had a merit council before the state did, for 50 years, right? For almost 50 years.
49, yeah.
And we've never had a problem, never had an issue. And now all of a sudden, we're from somewhere, somebody's decided we want to change the rule to 0 and get this body intimately involved in the day-to-day discipline in the sheriff's office. That is a nut I don't think you all want to crack in the first place, and number one. And number two, or an obligation you probably don't want to undertake. And number two, the sheriff has indicated quite clearly that we are not going to tolerate this intrusion into his day-to-day decision-making. So choose wisely. This is 50 years, it's worked. There's only 2 that have been happening in recent memory. I didn't do an exhaustive search. I don't know if we did an exhaustive search, if they'd find more. But all I'm saying is that the law has been in existence when it was made. The state made it 10, Knox County made it 3. 50 years it's worked fine, and then all of a sudden it's got to be 0. Y'all are undertaking getting involved in the day-to-day business of the sheriff and asking the sheriff to have to ask your permission to discipline his officer. That's going to be a fight. I don't know why we're picking fights. We're trying to get along with the mayor council these days. I don't know why we're picking fights now. But
Sir,
that's all I need to say.
Would you mind answering a question for me,
Yes, sir.
please?
Yes, sir.
I'll
try.
Yeah, that was the verbiage. Could you try? I wasn't demanding. The term private act, just for our education and edification, if you could explain that term.
A private act, and Myers can chip in on this as well. This is pretty standard stuff for lawyers. A private act is an act passed by the legislature in Nashville that by its nature, by population, usually it applies to only one county.
Okay.
So what happened in 1973, there was an act that was passed, usually at the request of one of our local members of the House of Representatives, that was passed that just applied to Knox County usually by population. 4 years later, because he's right, we had ours in 73, and then the state put theirs in 77. 4 years later, they put theirs in, and it's very, very, very similar. Did that explain it to
Yes, it
everybody what a
did.
private act is? Okay.
Mr. Valiant.
So I guess the issue that I've got initially is I think we just discussed that the 3-day suspension is being used, or any suspension of any kind is being used as a disciplinary measure. And I guess to answer the question about where it came about, I mean, specifically, we've had employees reach out to the Merit Council saying that, expressing frustration and expressing that they don't feel like they're protected and expressing that they've got problems with the way everything is currently operating. So perhaps for 50 years, things were okay, over the past 50 years. But I'm just saying that this has come about in a response to what we have heard from employees directly. And I know that the purpose of this board and body is to protect the employees from political activities of the administration. And, I think the case that you specifically mentioned a second ago involving the car, if I'm not mistaken, the final disposition of that was that the sheriff was found to be acting arbitrarily under those circumstances in that specific case. And the problem, the problem is if an employee loses pay, for 3 days or 10 days or any number of days, there are issues. If the purpose of this body is to protect the employees and make sure that they are protected, if an employee chooses to grieve a matter and say that they have received a loss of pay and that it was an inappropriate loss of pay, I think that should be a grievable matter. But I think under the circumstances where, hey, if they get suspended, and like you were saying, they knew it was coming, they understood what they did, it doesn't seem like that there would be any problem with that. But if they've lost 3 days of pay or 10 days of pay or however many days of pay, and there's not been a clear-cut understanding or a clear explanation of that, it seems like that should be something that is a grievable matter.
Well, for those of you that aren't aware of what he was referring to with regard to the car, remember one of the voters in that body was the guy that was wearing the political garb of the sheriff's opponent. So that's exactly what it is that we are trying to protect you all against, is getting involved. So when we have those kind of votes, I don't give any credence to what the last Merit System Council did. They were playing politics from day one. Secondly, anytime you talk about a political disposition, if the sheriff has done anything politically, remember, and I've been doing this for a very long time, I don't play politics, I don't play games. I've been here 35 years doing this. A sheriff that I've worked with, none of them, they can get irritated, they can be annoyed by the Merit System Council, but they're not afraid of a Merit System Council. You know who they're afraid of? United States District Court judge. If we are found guilty of suspending somebody for even a day for political reasons, that's a 1983 action against the sheriff. It's personal liability. So when they act like, or when Mr. Valiant wants to act to you like they have no remedy, that's simply not true. They have the ultimate remedy, and a remedy that you all cannot provide, and one that does absolutely take a sheriff like, okay, if we're going to play politics, this is going to cost me. And pat myself on the head. I've been here 35 years because I've never had one do that, and if I ever do, I'll be gone. So thank you very much.
I've got some comments that I would like to make for clarity, okay?
Okay.
We're at this point as a result of an education session that was put on by one of the commissioners that delved into this stuff.
Okay.
He's aware of that, okay? I was sitting on the merit board at the time of the car deal. That current merit board ignored the law.
Exactly.
In making their decision, okay? What I would suggest is in the future, so that we don't end up with unclarified actions, okay? The Sheriff's Department didn't have anyone at the education meeting for the merit board. You guys need to make sure you've got a representative there so that maybe that can help prevent us from going in the wrong direction.
Point taken. We try to stay out of politics. I
Well,
promise.
but that's factual stuff that we're dealing with. I understand that, okay? I stated at this last meeting, and I stated at that other meeting, that we needed to be careful that we did not interfere with the sheriff's ability to discipline. And I think that what you've said and what has been said today is we've made a good discussion of this matter. That's became very clear.
All right. Thank you, sir.
Mr. Vaughn?
More so a question and then a comment. I think thank you for asking for the point of clarification and also sharing a little bit about the prior board and that involvement, because that was really helpful. As we shared in the previous motion, speaking about board members' involvement in political activities, similar to this, is it something that we can look at as a board or either create a committee similar to work with in the sense of what a recommendation would be, if it's leaving language previous or coming up with a new verbiage to make it more current? I think what was dated and shared was dated in past tense, but what's more current, that we may be able to put something together as a body, have a conversation, and maybe we can look at having a sense of understanding, coming to a middle ground to make sure that we're not conflicting with what the sheriff's responsibility is, which I think was a good illustration as far as discipline officers, and you shared that as well. It's something that it's recommended to the board that we can look at pausing, again, this discussion right now, looking at further enlightenment for us, because even the information about the Private Act and everything was very helpful. It's good to know the information, but having some more enlightenment to make a really stern and not stern, but a good educated decision moving forward to make sure that we are not putting ourselves in a situation that might be conflicting in the sense of having more involvement on the disciplinary side. So opening it up for conversation, also lending that to you, Mr. Chair, as far as that's something you may recommend of doing something similar. We have further discussion and further enlightenment.
Thank you.
Thank you.
Mr. Valiant? I'm sorry, Mr. Gates, I believe you're next.
Yeah, I just have a couple of questions. The first question being is that what really is changing is from the idea that you can grieve an offense, right, from 3 days to 1 day. So the grievance in of itself doesn't necessarily mean that it would, I'm just wondering, would that mean it would interfere with day-to-day operations? Because you can suspend them regardless of the thing, it just then they would have the right to reserve the right to appeal. Is that correct?
The problem, and like I said, I've been doing this a very long time. I hate to keep going back to that, but the administrative cost of having one of these hearings, the hearing that we had over the car was over a 3 or 4 month period, right in the middle of an election process. There were 2 litigations that were filed. We had dozens of administrative staff get called as witnesses. The idea that the sheriff, who is the ultimate deciderer, to use George Bush's phrase, the deciderer of these issues, is going to be material. If I'm representing, and I've only been on one side, but if I'm representing an employee, the sheriff is going to be there. The sheriff, if I get to appeal a 1-day suspension, I'm going to have the sheriff sit here and explain to you what it is. So now we got a sheriff in an agency with 1,000 people, with 3,000 people in jail, sitting around with probably his chief counsel and himself and probably his chief deputy and whoever was involved in the actual event that caused the discipline, all having to testify. Because I know lawyers, good lawyers are good folks, and they are going to dive way down into the nitty gritty, and it's going to take some time. That's why I said I'm not sure you guys want to get involved in this, because this is not. You can't have a 20-minute hearing on this. I promise. You put a lawyer involved, and it's going to be a 2-day, 3-day, 4-day massacre, and that's what they've always been, sir. I apologize. That's just the history of it.
I understand, and this was more just to go to, it was kind of the preface to my next question.
Okay, I'm sorry. Then I
Yeah,
answered
so-
more than you asked.
Yeah, well, I appreciate you being so candid. So, my first question being is the length of, and then it appears to me that you're saying that for the sake of judicial economy, is the best way to put that it makes more sense for this thing to be able to preside because of the limited time, correct?
I'm sorry, I didn't get that. I wouldn't call it judicial economy.
Well,
It would be economy for you all. It'd be administrative economy for us, in the sense that, we're going to have a sheriff make a determination that somebody needs 2 days off to get his or her attention because they keep violating a single rule, and the sheriff realizes, okay, 2 days is now going to cost me and my administrative staff 5 in front of a merit council.
I understand. And then I guess my next question is, you did say that this happens pretty rarely, right? And-
The 3-day suspensions happen, 3 days or less happen very rarely. Yes, sir.
Okay. So, and to me, I was just trying to make a point of drawing those two things together, right? Saying that this would cost a lot of time, money, effort, energy for everybody involved. However, they do happen rarely, so it was just more for my clarification.
I understand your point, but and I would make this counterpoint, the impact is huge. Because even if it is a minor number, if a sheriff has to, in the back of his head, think, okay, I'm trying to get this guy or gal's attention, before I do the ultimate, before I terminate somebody, I'm going to give them a 2-day, by God, you need to do it the way we tell you to do it. And instead of having it that way, we're going to have to choose, okay, we're going to have a 4-day storm, then you're either going to get a sheriff who doesn't want to do the hard work of disciplining, because it's the least fun that we do the hard work of discipline. He's just going to say screw it, and then discipline goes. Or you're going to have some guy that comes in and says, all right, if I'm going to have a hearing, you're fired. Got it? I'm not sure this is going to have the impact that whoever is deciding that they need this is actually going to happen, because the sheriff can go one of those 2 ways. And I've worked for 5 with 5 different personalities, and I can see a couple of them saying, if I'm going to have a hearing, we're going to make it worth my time. So, like I said, be careful about this.
Appreciate your time. Thank you.
Now, Mr. Valley. All right. Ms. Wilson, did you have a comment?
So then, with the way that it's drafted right now, there is an exception that would say, so the primary purpose of this board, is clearly stated to protect the officers from political activities of the administration. So then right now, under the rules and regulations, it would say that a grievance subject to a hearing before the Merit System Board of Directors is defined as any of the following actions by the sheriff, and it would involve a suspension of longer than 3 days, where an employee is given a cumulative suspension of more than 10 days within any given 6-month period. It seems to me like, okay, the problem is during that time period, the employee would still have no ability to redress that. The employee would have no, if it's happening rarely, it shouldn't be that much of an issue, but still right now, the employees are left without the opportunity to address, hey, I believe that this less than 3-day suspension or this 3-day suspension was politically motivated, or I believe, there is no articulable. The problem right now is if it happens, if it were to happen, I'm not suggesting that it happens regularly, but if it were to happen, right now there's absolutely no avenue to address a suspension of less than or equal to 3 days. It would have, the employee would be without any avenue of redress. Well, sure, they could go to the district court, but I mean, I'd ask the question then, how many employees in the sheriff's office have the ability to hire an attorney and sue the Knox County Sheriff's Office, which has significantly more resources, and go before a district court judge and go through that process? I mean, we're talking about, an action before this merit council could take a couple weeks. An action before the district court of the state of Tennessee is going to take, months or years, all over a couple of days suspension. It seems like the purpose of this board would be specifically to address something like a suspension of 3 days or less.
You address the political side. Let me remind you that the 1983 section has a fee shifting provision, which means that if anybody does feel like their suspension has been politically motivated, it's a 1983 action, and there are hungry lawyers all over this town that would jump all over that like ducks on a June bug. Anyway, I think that as Chief Purvis pointed out, remember that if you look through our administrative processes for discipline, there are multiple levels for the employee to raise his case. He's got the immediate supervisor, he's got the intermediate, he's got his immediate supervisor, her immediate supervisor, then they've got mid-level supervisors, then they have the chief, then they have the sheriff, and the sheriff can always change what the other folks have done. So to say that they have no recourse inside the system is false. To say they have no recourse outside the system is false with regard to the main thing that this body should be dealing with, which is politics. There's a court over there that is ready, cocked and ready to kick anybody's derriere that takes a professional law enforcement officer and disciplines him for political reasons. That's why you don't see it. You don't see it. So we're going over the same issues. I think I've made the sheriff's position very clear. Thank you.
Mr. Marshall?
I just want to clarify a couple of things. I've been serving on the board now for over 2 years. I have yet to have a single officer come to me with a complaint personally. And I don't see from what we've discussed today that there has been a problem associated with the current policy as it's enacted. So I'm of the opinion, if it ain't broke, don't fix it.
Ms. Willis?
I just want to make a comment. The fact that there are not a lot of suspensions that are less than 3 days is telling to me, and I think to change that to anything less than 3 days would be opening ourselves up to frivolous claims.
Thank you.
Just speaking from an HR standpoint and dealing with disciplinary actions on a regular basis, I think that would be the outcome.
Okay. Thank you. Mr. Vaughn?
I think my question was already answered, but I guess this is a point of clarification. You shared earlier, the representative from the sheriff's office, only 2 suspensions less than 3 days. Can you give us some examples of what type of, because I know you said this is more like a disciplinary action as far as like a warning per se, prior to going to another level. Can you just give us
The
some
reason I'm
examples of
looking
what that
around
is?
this is the chief of the jails who I know and the chief of patrol. They can
Yes.
give you the actual examples.
That'd be great.
If they can, or similar examples.
One I can think of,
Thank you.
the one that I can think of that I gave 3 days to, put evidence in the back of his car and left it while he went on military leave. That evidence was gone for 6 months. What am I supposed to do with it?
To me, that's a clear, articulable reason.
Sir?
That's a very clear reason for a suspension, though.
Yes, sir. Or somebody that totals a car twice within 3 months.
Right.
I've got to do something with him to.
Sure.
That's, and again, clear.
I think Chief Purvis has got one of Chief of Corrections.
Yes.
Just to give you a little synopsis there in regards to our disciplinary process. Usually, most of our disciplinary issues are resolved at the lowest possible level with performance counseling is where it starts, verbal performance counseling, if we're able to do that. Then we go into a written one, which those are done at the supervisory level. They don't have to have the sheriff's approval on them. That's trying to train the individual to get the action appropriate. When we come to the level where we're recommending days off, that's either a result of an incident that we have to act on it where there's unsafe practices. Maybe it's breaking state law in regards to the number of cell checks that are done during a period of time, and someone refusing to do that, or not taking a necessary action during a life safety situation. But typically, the only other category that comes into the days off without pay is when lesser means of disciplinary action have been successful in changing the behavior. And when we view that to continue on without taking a more stern disciplinary action would be negligent on our part in correcting the behavior that's putting people at risk. But that's the overwhelming majority of the ones in the corrections division. It's either repetitive, the same issue, or they're issues that rise to the level that they have to be dealt with very, very quickly in order to make sure that life safety is protected.
Thank you. Mr. Vaughn, did you have another?
Yeah, just to follow up.
Thank
So
you.
thank you for that clarification. That helped definitely answer my question. So I agree with a lot of our colleagues who've already mentioned it earlier. It's like Mr. Marshall said, if it's not broke, why try to fix it? So if the chair would be open to entertainment to amend the motion or maintain the initial language that was listed and reject the proposed change of language to maintain what has not been broke for over 40 plus years as shared by representatives of the sheriff's office, I will offer that as entertainment if you will entertain an amendment to the motion or whatever possible way we can look at removing
you.
that.
I appreciate that. Before we move on any conversation about the motion, I'd really like for us to be educated and ask the law director representative to prepare some type of a document on the private act explanation of, the legislative body passed a law and we are subject to those laws, and it's not a cafeteria. We follow all the laws. And I'm sitting here thinking we cannot be contrary to state law. I mean, these gymnastics we're involved in right now are mute because the law is this, and it isn't a policy of the sheriff's office. It's been in place since 1974. Go Titans! I graduated in '74. But the point is, I think if we receive that information, it's mute because we're not going to go contrary and be extraordinary and run amok. We're just not going to do that. As chair, I'm not going to, subject us to that type of evaluation by either a court or the county commission or whoever, because we took an oath to follow the laws, and I'm just going to ask the director to evaluate, or not evaluate, but open that up and give us the salient points of that private act that was passed by the state legislature and explain the operational guidelines within that.
Yes, sir.
Okay, and what I'd like is when we schedule, it looks like we'll have a September meeting, unless, and let me summarize. So I'm gonna table this motion. We're not gonna move on this. We're gonna have a explanation by the law director's office as to the private act, and then we'll it's just proposed, so I don't have to do anything. Yes, ma'am.
If we are going to do that, it might be beneficial. Does the sheriff's department have a progressive discipline policy?
Do you have a progressive discipline policy, Chief? But your levels of discipline are enumerated, correct?
The merit system
They're in the rules.
merit system in your rules. It has a progressive disciplinary process. We also abide by all the guidelines that the state of Tennessee provides in regards to that. And I meant to say this earlier, at each level of the disciplinary process, the employee does have an opportunity to respond. Even at the performance counseling level, they do have an opportunity to express their opinion if they disagree with the assessment at that level. And then for us, inside of the corrections division, it goes from that lowest level supervisor. If they recommend a disciplinary action beyond what we can perform and goes into administrative action, it goes through each level of the chain of command until it comes to the top level in that particular division, and then that division chief will take it to the sheriff with a suggestion for the disciplinary action. So there's multiple tiers of quality control, making sure that everything's been authenticated all the way through the command.
Thank you. Okay, that appears to be the last item on our agenda. Is there any, I'm sorry. Boatman.
Just have one comment on that. You know, as a board, we're being asked to change something that's worked perfectly for 50 years and potentially might stir up something we have no idea what could cause. So if we're going to table this, I'd just like for all of us to think about the potential problems in all this versus how something's worked perfectly for such a long period of time. And I think Mr. Marshall brought up something good. If it's not broke, don't fix it. And I think this has worked very, very well. And if the sheriff did a disciplinary action that was so heinous, there's a lot of attorneys that would take on that cause. So I think we need to step back and take some retrospect action on this before we vote on it.
Thank you, Mr. Boatman. I see no other comments. Thank you very much. So we need to have a brief conversation with Mr. Marshall, Mr. Valley, and Mr. Vaughn are going to be serving on this subcommittee regarding the one item. And how long do you believe that you need before you want to report back for that? So we meet at a minimum quarterly. So it's now August. So September is the last month of the third quarter. So we could, if you want 60 days, we could meet in the first month of the fourth quarter, which would be October. Is that enough time, or do you want more time?
That's fine with me.
Yeah,
Fine.
sufficient.
You said when in October?
We haven't set the date.
But our next meeting happens in October?
Well, we're required to meet quarterly, but not necessarily in October. We could meet any time in the quarter. We just have to, I was just thinking, if you need 60 days, that's fine. We can move it to November. There's no, of course, if there's grievances filed or something that's exigent, I'll notify or have Ms. Taylor notify the board that we need to meet.
That would fall in line with 60 days.
60?
What I'd say is we'll need to coordinate with the law director's office because we're going to need someone from their office, Myers, or someone sitting down with us as we discuss this.
Okay,
I imagine because of the Open Meetings Act, we're going to have to expose this and wherever so that people can come in if they want to watch our deliberation.
Okay, so then what I'll do is we won't set a date for the next full council meeting. I'll wait until I get an update through Ms. Taylor regarding your status, and then we'll call. We have to give 10 days. We have to give 10 days public notice for the meeting, so that we have plenty of time to, we have all that. So, anything else from the body? Thank you, ladies and gentlemen. We stand adjourned.